Applications for patents. Section 6 of the Patents Act describes the categories of persons who can apply for a patent. Section 6(1) reads, subject to the provisions contained in section 134, an application for a patent for an invention may be made by any of the following persons. Now, section 134 deals with international applications. We will be covering that in detail at the appropriate point. International arrangements, 134 specifically deals with notification as to countries not providing for reciprocity. So, subject to that provision, the following categories of persons can make an application. Now, if you see on your screen, we have given cross references to section 4, 5, 7, 134, 135 and section 2, 1y. These are the relevant cross references. So, you can check them to see how this provision is related to the other provisions of the Act and the rules. The first category of person who can apply for a patent is a person claiming to be the first, true and first inventor of the invention. Now, the true and first inventor is defined in section 2(1)(y). The true and first inventor is defined as a person that does not include either the first importer of an invention into India or a person to whom an invention is first communicated from outside India. So, what the definition does, rather than explaining who a true and first inventor is, it just says the two categories of persons who will not come under this definition. If you import an invention into India, then if you are the first importer, you will not be regarded as the true and first inventor. Section 48 refers to importation as one of the rights protected by a patent. A patent, when it is granted, also gives the right to import an invention. So, this very specifically says a true and first inventor is a person who has to do something with the creation of the invention, not merely importing it. So, mere importation of the invention into India will not make you the true and first inventor. Similarly, a person to whom an invention is communicated is first communicated from outside India. Now, in the earlier occasion, the product came into India. In this category, the invention was communicated, and you will know that invention can be communicated in various ways. There are communications can destroy the novelty of an invention. There are secret communications or protected communications, confidential communications. So, when an invention is first communicated to a person in India from outside India, even that will not qualify for a true and first inventor. So, that brings us to the question, who is the true and first inventor? True and first inventor is the person who conceives and develops the invention. We could also say that he is the person who puts into practice the invention for the first time. If you look at the history of patent law, true and first inventor is a phrase that developed in the United Kingdom, and we have cases to say which describes how this concept evolved. An analogy in understanding the true and first inventor will be the author of a copyrighted work. The author of a copyrighted work is given a special status in copyright law. He or she is a person who makes the original work for the first time. So, the person who makes the invention for the first time is regarded as the true and first inventor. Just as you cannot have a copyrighted work without an author, similarly, you cannot have a patented invention without a true and first inventor. So, inventor is the person who creates the invention, and patent law does not recognize an invention which does not have an inventor. So, the explanation to the definition of true and first inventor actually excluded by mentioning a person who imports for the first time and a person who communicates for the first time. It actually excluded, or it did not say anything about the person who actually created the invention. So, we understand the true and first inventor as the person who created the invention for the first time, and analogy, as I mentioned, is the author of a work, a written work or a literary work, which can be subject matter of a copyright. The author may later on assign his right of publication to a publisher, and the publisher may publish that book. So, even if there are publishers, or even if there is a publisher behind a book, we would normally expect that book to be authored by a person, a legal entity. So, in this case, when we find an invention, we expect there to be a person or a group of real legal entities behind them, whom we refer to as the true and first inventor. It is possible for the true and first inventor to assign the invention to a third party, and the person to whom the invention gets assigned is called the assignee. So, it is possible for, but still, even in the case of an assignment, it is critical to have a true and first inventor. Now, the proof of this statement you can find in Form 1 of the patent rules. So, if you look at Form 1, you will find that Form 1, which is the first form in the second schedule deals with all the forms. You will find in clause 4 of Form 1, the inventors have to be mentioned, and in clause 12, which deals with declaration, the first declaration is the declaration by the inventors, where the inventors would state or declare, if there are multiple inventors, we the above named inventors are the true and first inventors for this invention, and declare that the applicant herein our assignee or legal representative. Okay. Now, this tells us that even if there is an assignment of the invention, it is necessary for the inventor to make a declaration that they are the true and first inventor. A declaration made by the true and first inventor may not have any bearing on determining who invented the invention for the first time. Though the phrase refers to it as the true and first inventor, this phrase will not be critical in determining disputes with regard to inventorship, for the simple reason that India follows the first to file principle rather than the first to invent principle. The United States used to follow the first to invent principle till some time back, but in 2013 they amended the law, and now, and United States used to be a lone exception in that. Now they universally follow what other countries do. The way to determine inventorship is to determine who had first filed the invention. So, we follow the first to file principle, and so the first inventor, but in the course of history this was not the case. There were instances as patent law developed where inventors would litigate or have a legal dispute with regard to who invented the invention for the first time. So, but this is something that has been carried over from history, so that is why you still have the phrase true and first inventor. So, we just now saw that how the phrase true and first inventor is defined in a manner in which it excludes two categories of people, the person who first imports the invention for the first time, and the person who first communicates the invention into India for the first time from outside India, obviously. Now, this is the first category of people who can make an application, because the section 6 talks about who can make a application for a patent. So, the person who invents the invention, who creates the invention for the first time, can file an application for a patent. So, that is the first category. The second category is mentioned in 6(1)(b). By any person being the assignee of a person claiming to be the true and first inventor in respect of the right to make such an application. So, the second category is a person being an assignee of the true and first inventor. So, the right to make an application comes from the true and first inventor, because this category says that if the true and first inventor assigns the right in an invention, then the assignee can step in as the applicant. So, we understand that there are two categories of people to whom an invention can be related to. The first category is the true and first inventor, who is the maker of the invention, and the second category is the applicant who can apply. So, the person who makes the invention need not be the applicant in all the cases. In 6(1)(a), the person who is the true and first inventor, the inventor can actually be the applicant, but in most cases the applicant will be the assignee. For instance, if a person works for a institution, a research institution, the scientist who works in the research institution will be regarded as the true and first inventor of the invention, but most likely the patent will be filed in the name of the research institution itself. So, the research institution will be the applicant and the scientist who came up with the invention will be shown as the true and first inventor. Now, the right to make the application by the research institution will be through an assignment. So, the true and first inventor, either through the employment contract or by through some special arrangement, will have to assign the right in the invention to the assignee, that is the research institution, for the research institution to make an application. So, the assignee is not the inventor, but the assignee gets the right from the true and first inventor. So, that is the second category. Just as the true and first inventor is expected to make a declaration in form 1, similarly the assignee also needs to make a declaration in form 1. Now, the declarations are, as I mentioned, in clause 12 of form 1, and you will find in the third part in clause 12 declaration by the applicants. There you will find I am /v are the assignee or legal representative of the true and first inventor. So, this statement needs to be made by the assignee. So, the assignee can only get his or her right from the true and first inventor, and the assignee has to say that there is an assignment. The third category is mentioned in 6(1)(c) by a legal representative of any deceased person who immediately before his death was entitled to make such an application. Now, we saw in A and B there are only two kinds of categories of people who can make this application. One, the inventor or the assignee of the inventor. Now, the third category says they could be a legal representative of a deceased person who immediately before his death was entitled to make that application, which largely means the legal representative of the true and first inventor or the legal representative of the assignee. So, this is a clause that covers instances where someone was entitled to make an application, but could not do it because of their death. In such cases, the legal representative, whoever would inherit them or whoever would succeed them, or whoever will have the rights of that person, will be entitled to make an application. So, this covers legal representatives of an inventor as well as legal representatives of an assignee. In the case the assignee is a body corporate like a company or an organization, then again legal representative will mean obviously the death of a body corporate does not arise, but the person who was entitled to make the application, if that person dies, then any person who can step in as the legal representative of that person can make the application. And section 6(2) states that any application, an application made under subsection 1 may be made by any of the persons preferred to therein, either alone or jointly with any other person. So, the true and first inventor can jointly make the application with the assignee if he had not assigned the entire invention to them. The true and first inventor could also jointly make an application with a legal representative of a deceased assignee if the deceased assignee is an individual. So, you could have an application made jointly by the people mentioned in this category, or they can make that application alone.